Start, if you could just introduce yourself and a little bit about your background in concussion law.
My name is Paul Anderson. I'm a practicing attorney in the state of Missouri. Practice at a plaintiff side class action complex litigation firm. While I was in law school, I started a website called NFLconcussionlitigation.com. I noticed that the NFL was being sued at a rapid rate by former players, claiming the NFL hid the long-term risk of concussions and actively misrepresented the link between repeated hits to the head and later life cognitive decline. So I noted that concussion litigation is an emerging area of sports law. So I decided to create a website to try to get my foot in the sports law arena. And then I started tracking each lawsuit that was being filed. And from there, I guess the media thought I semi-knew what I was talking about, and so they started asking me questions, and I started building relationships with media members and former players, and really learning their story about their take on the NFL and the Players Association.
Well, when you agreed to participate in our panel today, what was one of the most important things that you wanted to express on the panel?
Right. Well, concussion is a serious injury, and for too long we have thought that it's just a benign injury that quickly heals itself, and it's just a ding. But that is clearly not the case any longer, and the awareness and education about concussion needs to be brought to the forefront, and in the past few years it certainly has, which is a good thing, and I think that's one of the best things about this litigation. And this is a very important issue that affects all of our lives, and the main reason why I came here today is so we could have dialogue and discourse on concussion and how it has impacted numerous lives.
And some of those lives that you really talked about that were being impacted the most are the NFL retirees. And you mentioned that they're pretty much left to fend for themselves, not because of anything they did, but because of failures of the NFL Players Association. So if you could talk a little bit about that.
Right. I think there's probably a solid argument that if anybody's hands are dirty in this litigation. In other words, if the NFL was negligent or indeed fraudulent in their conduct towards the players and their conduct surrounding concussion, the NFL is not the only one. I think the Players Association was created to represent the interests of the players. And the NFLPA, presumably, was privy to the exact same independent scientific studies that the plaintiff's lawyers are alleging the NFL concealed and created. And the question becomes, one, was the NFLPA complicit in the NFL's actions? Or two, was the science just really not there and the allegations in the complaint are not true? And that's a question that will be determined as litigation proceeds. There's a chance that the NFLPA could end up being a defendant in this case. But at the end of the day, the real issue is a labor issue to an extent. And the retirees for far too long have been pretty much used up and tossed aside after their careers are over. Their pensions are minuscule compared to Major League Baseball. And that again goes to the failures of the Players Association. Why haven't they negotiated better benefits for the retirees?
All right. You talked about a little bit, I know it's really tough, I haven't mentioned that on the panel, but just maybe give a prediction of, maybe not the results, but how this litigation may unfold and some of the key issues in it.
Right. Well, there are certainly multiple issues facing the players. This litigation is almost a law professor's dream, where you have just an issue spotter all over the map, several moving parts. But first of all, there's this threshold issue of preemption and whether the players' claims are inextricably intertwined with the terms of the collective bargaining agreement. Cases against the NFL, teams, Major League Baseball, personal injury cases have not fared very well. And so the NFL is using that argument to say the players cannot make out their claims without the court having to interpret various provisions of the CBA. And if that occurs, if that interpretation is required, then that triggers preemption. In other words, the players' claims are dismissed, the courtroom door is shut, and the players have to proceed to arbitration. If the players, however, are able to get past that arbitration issue and the matter of preemption, successfully defeat the NFL's motion to dismiss, Then the next stage of the litigation will be discovery. In discovery, the plaintiffs will have an opportunity to depose various witnesses to determine exactly why the Mild Traumatic Brain Injury Committee was created, why Dr. Elliot Pellman, a rheumatologist, was named to head this committee. A rheumatologist deals with knees and joints, and this committee's name was the Mild Traumatic Brain Injury Committee. So the discovery and the allegations that really have teeth in this case will revolve around the conduct of the Mild Traumatic Brain Injury Committee. There are other multiple issues, and just to name a few, the statute of limitations. You know, there's players that played in the 50s and the 60s and 70s and 80s. There's probably a good argument that their claims may be dismissed on the statute of limitations argument. You generally have 2 to 4 years to file a claim. The players are going to say, well, we didn't discover that these defendants committed wrongs to us until just recently. So we can get past that statute of limitations issue. Assuming they get past the statute of limitations issue, then there's still going to be causation issues. Causations, how can you prove that the NFL's wrongful conduct, alleged wrongful conduct, caused the players' injuries? It's going to be difficult. This litigation is going to be driven by the medical community, medical experts. Another issue becomes, was the science really there? The science has evolved so rapidly in the past few years. Can we really say that the NFL knew about the long-term risk of concussions all the way since the 1920s? I think that's going to be a very difficult argument to prove. And even if the NFL did owe a duty to the players during that time, I'm not so sure they breached that duty prior to maybe the early 90s and had a duty to warn about the long-term risk of concussion. And if that's the case, probably several of those claims prior to the 90s will be dismissed. And then from there, again, that causation issue is going to be tremendously difficult. And that's where the medical expert testimony will have to come in. And then from there, if the players are able to find that smoking gun memo that says, yes, we hid the link, we, the NFL, hid the link so we could monetize on the big hits that occur in the NFL, then that could be a real turning point in litigation. The chances of that occurring are probably slim, but we'll see. That's what the discovery process is here for. And then if all those pretrial proceedings are ruled in the player's favor, then the next stage will be a trial. And the plaintiffs will have an opportunity to persuade the jury that they deserve justice. And if justice is served, it's going to be a pretty expensive bill for the NFL to foot. But I do think, certainly, that the NFL, no matter how big a global settlement and how big a judgment is rendered against them, the NFL will be able to withstand that hit and will continue to remain the most popular sport in football.
All right, that's it. Thank you very much.